I'm going to share a spilled milk story with you. Investigation reports that are published by regulators are often good examples of things that have gone wrong for others, with lessons that you can learn in respect of your conduct as a DPO. In this particular instance, the investigation was in relation to personal data issues arising after an M&A transaction. EC Healthcare is a business in Hong Kong that has grown and developed in the healthcare sector by way of acquisition. It has built up 39 brands. 28 of those used a centralized data sharing system in respect of patient and customers' personal data. So this was health-related data, which can be quite sensitive. The EC Healthcare did not have a centralized personal information collection statement that notified data subjects and patients of the prospect that their personal data could be transferred and shared across the group through this centralized data system. This ultimately gave rise to 2 complaints to the Office of the Privacy Commissioner for Personal Data in Hong Kong, or the PCPD. After its investigation, the PCPD issued an enforcement notice and required EC Healthcare to stop sharing of personal data among the different brands in circumstances where that had not been consented to by the patients and data subjects in question. They also required EC Healthcare to ensure that the collection of personal data in future that was going to be shared across the group was done in a lawful manner. This in turn led to the requirement that they update their policies and procedures to ensure that they could demonstrate lawful compliance with the requirements of the laws and regulations in Hong Kong in this regard, and to provide staff training and awareness. EC Healthcare were required to report back to the PCPD to demonstrate compliance with the enforcement notice, noting that failure to comply with an enforcement notice can be a criminal offense in Hong Kong. So this was an incident of significance and importance because although it was 2 particular complaints that brought the investigation about, the data in question was to a large number of data subjects. So the points that the PCPD recommended for all to take note of going forward include being aware of the personal data privacy implications of conducting an M&A transaction, so that those issues are foreshadowed in the transaction process and are dealt with as part of that process. Obtain consents and permissions or notifications in circumstances where this is necessary or required by applicable laws. In Hong Kong, if you notify data subjects at the time of their collection of the purposes for which the personal data will be used, then you may use that personal data for those purposes, but you need a fresh express consent if you need to use the personal data for a new purpose. So using personal data by a group company could well involve a new purpose. Consider conducting a privacy impact assessment in relation to the impact to the privacy of personal data of customers and other persons involved in the M&A transaction, so that you are able to demonstrate sensitivity to the issues involved and compliance with lawful and legal obligations. Make sure that policies and processes are in place to either obtain consent if data sharing is contemplated, or to segregate data if consent is not given. Introduce privacy awareness and training programs so people are aware within the organization of personal data to which they have rights to access and use, and in what circumstances and how. Consider introducing a privacy management program so that data privacy across the group, from the highest echelons of the group downwards, follow a coherent policy that can then be applied and rolled out to newly acquired and integrated businesses. So these are the recommendations in this particular investigation report, but they apply generally to all businesses in an M&A context, and not just in Hong Kong, but wherever those transactions may occur.